text was drafted, at that point there was still a special place for a particular religion. Now that has been removed, happily, but we still see doctrinal teaching so influential in the text. We still see those religious references you've spoken of, Ruadhan. We still see, this religion dominating throughout. And that's, a key reason why we need that radical rewrite. It's a key reason to say, yes, the text has atrophied. It's no longer fit for purpose in a 21st century secular pluralist republic. And I suppose the other point to make is, I've said a republic. This is not the constitution of a republic. Nowhere within it is the word republic mentioned. And of course, infamously, well known, in 1937 there was what we might now call constructive ambiguity in the language. The name of the state is Éire in the English language Ireland. No reference to the status of the state, because that was still contested. Only in 1948, much later, by way of legislation, does the state become officially, formally, legally a republic. So again, you have a status that's ambiguous in the text, not a republican constitution in terms of governance, and of course, with that religious ethos, not a republican constitution in the sense of the secular pluralist republic that I believe we all aspire to living in, and that indeed we do live in, because that's the reality in Ireland today. So, long-winded answer, Ruadhan, but yes, it's atrophied. Yes, it's too religious.
We'll definitely come back to the question of the Republic, because I have a few questions prompted by the discussion with Sam McBride on that very question later. Rossa, does it matter that religion is so prominent in the Constitution? Jared Hogan, who's now on the Supreme Court, has written a lot about how, actually, if you look at the deep structure of the Constitution, if you look at the fundamental rights provisions and others, what's remarkable is actually the extent to which this document reflects secular values, liberal democracy, separation of church and state, and so on.
Well, thanks, Ruadhan, and good morning, everybody. I'm not a politician, and I'm on a controversy-free diet, so I don't actually have any political views, unlike Ivana.
What happens in Glenties?
What I will say is as follows. Every constitution, when you look at it, is a product of the time and place and people who drafted it. So whether that's the constitution of your local pitch and putt club, or whether it's a constitution of a country, that is always true. If you look at the federal constitution of the United States, a country we don't live in, but a country whose politics and law we do absorb through the overspill of American media in particular, many of you, although you're not American lawyers at all, will be familiar with some of the critical amendments to the federal constitution. So you're probably broadly familiar with the First Amendment that protects freedom of speech, the Second Amendment, which protects the right to bear arms, and the Fifth Amendment, which is the right of silence. Almost none of you, I dare say, will have heard of the Third Amendment. The Third Amendment to the US federal Constitution provides protection against American citizens from being compelled to quarter soldiers in private residences. It's a provision that has not been the subject of a single constitutional case, not a single decision of a federal court in 250 years. And if you come to that in 2025, you would have no understanding as to why it's there at all. It looks like an anachronism. But of course, you have to go back to the timing of it immediately after the Civil War to understand why it was thought to be relevant at the time. So when you're looking at a constitution, you will very often find what you might consider to be historical artefacts that don't have any current resonance, but were important to the drafters at a time. In terms of analysing the Irish constitution, a really important point to make, though, is that the people remain sovereign. It is a relatively easy thing to amend our constitution, and since 1937 it has been amended on more than 30 occasions. So you can take a view on what Ivana said, you might strongly agree with it, and the people remain sovereign. To the extent that there is a political wish to amend any element of the Irish constitution, a bill to amend the constitution can be passed by both houses of the Oireachtas and put to the people by way of plebiscite, and by way of simple majority vote, the Constitution can be amended. So in that sense, our Constitution, I think, is a more dynamic instrument than sometimes is given credit for.
That's true, David. So this is relatively easy to change. All you need is 50% plus one to effect a constitutional amendment. So why does no government, if we can all agree, or if they feel a majority could agree that this is anachronistic, inappropriate language, why would they not go to the people tomorrow and, let's say, take out the preamble?
Yeah, it's a really interesting question. As Rossa was saying, 31 amendments over the course of, less than 100 years. We've had 43 proposed amendments, and so, some of those have been rejected, and we've all voted in referendums where that has happened. So it's a fairly robust amendment process. It's possible to change the Irish Constitution. We have done it. In global terms, it's kind of a medium level of difficulty. Rossa was talking about the US Constitution. That's at one of the highest levels of difficulty, alongside maybe the Canadian Constitution as well. Lots of constitutions can be changed by parliaments acting alone, or parliaments with supermajorities or so on. So we do have a hurdle, which is you have to go out, you have to ask the people. As Rossa was saying, one of the principles of the Constitution, as De Valera put it, is the people are the masters, right? So while it's definitely possible to amend the Constitution, the referendum process, I think, does limit what we propose in practice. Why? Because it's hard to explain constitutional changes. It's hard to discuss what we mean to do when we amend the preamble. If we put in new symbolic language, we'd have to have a broad national discussion and a vote on what that symbolism was going to be. And for reasons I would struggle to fully explain, successive Irish governments have, I think, been wary of purely symbolic changes to the Constitution. When we change the Constitution, or propose a change, as we did say last year with the family and care amendments, which people will remember. People are very keen to say there might be important symbolism here, but we're also making important legal changes that are going to have concrete legal effects. We very rarely say, here's a constitutional change, it's just about better vibes. We just want to make the Constitution feel better. We've probably done that once in the 1970s when we removed the special position of the Catholic Church. One of those clauses that was particularly sectarian had no legal effect, and it was a symbolic removal of a symbolic provision. Other than that, I think we've been reluctant to engage in changes in constitutional symbolism. And we've been changing bits of the Constitution in an accelerated way. 30 of the 43 referendums that we've had have taken place since 1990, thereabouts. So the pace of change has been accelerating, but we still haven't said, actually, we need to rethink some of the structure of this, some of the symbolic language. Instead, we focus on discrete changes where we can say, we need to change this power, we need to add this right, we need to legalise same-sex marriage. Those are all really important, but we haven't been willing to embrace the symbolic question in that constitutional discourse.
So you're pro-vibes-based amendments? I'm
pro-vibes in all respects. Yeah, no, I think there's a great line in a classic Australian movie called The Castle, which is about the Australian Constitution, and the lawyer gets up and he says, this is blatantly against the Constitution of Australia. And the judge says, which part? He says, no particular part, it's just the vibe of the thing. And while that's a very good joke for a film, it's also true, the vibes of the Constitution matter just as much in many ways as the legal text that we write down, because it colours how we read it, and it colours what the text will actually do when it's invoked in the courts or invoked in politics.
Well, with the greatest of respect, which is what lawyers always say when we're about to disagree, I think vibes do matter. And in fact, David, you've sort of contradicted yourself, because arguably, well, not arguably, I think fairly clearly, in a constitution, in a written constitution, nothing is symbolic in terms of language. Every word, every phrase in the Constitution is of more than symbolic importance and value. I think you've acknowledged that as well. Because, of course, this is our fundamental legal text. This is the foundational text of the state. And so it does matter. And even if we were to say, well, what would it matter to change the word he in the presidential article to the word he or she, or even, dare I say it, just the word she? Would that matter? It would matter. It matters to then judges who are called upon to interpret the Constitution. It helps to shape what our Supreme Court has called the constitutional identity of the state. It helps to shape the way we as legislators in the Oireachtas frame our laws. It will help the President in considering with the Council of State whether to refer bills to the Supreme Court to see if they're repugnant to the Constitution. So I think language matters, and no language in the Constitution is purely symbolic. And, may I say, I think I've had the full MacGill experience in my first time here, in a very short time, being in Roddy's bar until very late last night in the company of some of my panellists and fellow panellists, and also doing the Port New swim with Bridget Laffin this morning, which apparently is a rite of passage. But, in the course of that, I've discovered, as I would have expected, that all of you are hugely engaged. All of you are, as Irish voters are, hugely engaged with the text of the Constitution. You may not have read it, as Ruadhan has said, cover to cover, but I think all of us here are aware of how closely engaged people get in a referendum process with the text of the proposed changes. And David referenced the family and care referendums last year. The wording of those proposed referendums, which of course were defeated, that wording was so closely parsed and discussed, late at night in bars, early mornings in swims, around the country. And that's why people ultimately rejected. They were unhappy with some of the perceived lack of clarity in the wording and so on. So I think wording matters in the Constitution. I think where you have references throughout to God, where you have religious ethos permeating the text, often it matters as well what's excluded from the text. So, not only is it quite religious in tone, there's also a sense that the rights in the Constitution are very much civil and political in nature. They're not the economic and social rights. For those of us on the left, we would like to see, for example, a right to housing in the Constitution. That's not there. Instead, you have what we often call, the civil and political, the first generation rights, which are really freedoms. The freedom to express your religion without state interference, the freedom to go about your business without being unlawfully detained by the state. These are some of the freedoms in the Constitution, but enforceable rights, like the right to housing, are lacking from our Constitution in general, and the tone of it is that sort of more liberal, less socialist, less communitarian, and that as well, I think, is problematic in a modern republic.
Rossa, we have a lot of referendums. You've both mentioned that, and we're atypical in Europe for that. If we take same-sex marriage as an example, right? So there was an opportunity, or it was put to the courts at one stage, that they might introduce same-sex marriage through that route. That didn't happen. It went to referendum. Which is the better mechanism?
Well, I think that's a really important question, but to answer it, I think you need to begin by asking, how do you interpret a constitution? And for a mixed audience that includes some lawyers, but mostly non-lawyers, that's actually a pretty complicated question in itself. The leading Supreme Court judgment now on how to interpret our constitution, I would say, is Mr. Justice Murray's judgment in a case called Highlands, where he distilled and summarised the principles. But in short, a constitution doesn't mean whatever the judge thinks it should mean when he gets out of bed, and depending he or she, Ivana. The constitution is not a subjective document. There must be objective principles that govern its interpretation. The meaning must be found from within the document itself. There are principles of harmonious interpretation. You don't consider one provision in isolation from the whole. So in broad terms, there is a sort of a toolkit by which you construe the document. In the litigation to which you referred in your question, that was litigation brought by Catherine Zappone almost 20 years ago. She subsequently served, as you'll all recall, as a government minister between 2016 and 2020. But at the time, she and her, I need to be careful, possibly partner as a matter of Irish law, but they may have been married in a foreign jurisdiction. They were married in a foreign jurisdiction, but the case they brought was a case that they ought to be entitled, as a matter of Irish constitutional law, to be married. Now, the case failed. Ivana knows more about the case than me, actually. I've just read it, but Ivana, if I'm not greatly mistaken, acted in the proceedings on their behalf. So the argument was whether the family and marriage, in the sense referred to in Article 41 of our document, could be interpreted now in the 21st century to encompass same-sex marriage. And as a matter of construction or interpretation of the Constitution, Ms. Justice Dunn in her judgment said it couldn't. Now that is a question of constitutional interpretation. It's not a question of whether Ms. Justice Dunn or any judge thinks same-sex marriage is a good thing or a bad thing. What was found by the court was that the Constitution, in all of its references to man and woman and marriage, was clearly referring to opposite-sex marriage, and it was impermissible to construe or interpret the Constitution as meaning something which the text simply couldn't bear as an interpretation. So the courts didn't find a constitutional right to same-sex marriage. As everybody knows, because it's now 2025, the outcome was political pressure, ultimately legislation through the Oireachtas, ultimately a referendum, and a popular vote by a very large majority to amend the Constitution, subsequently followed by legislation to permit same-sex marriage. Ruadhan's question of me was which is the most legitimate, and I think that really is an important question. The issue is not necessarily whether you're in favour of same-sex marriage. The question is how you think that change should be brought about. I personally think it's very difficult to disagree with the proposition that the way we did bring it about has an awful lot more democratic legitimacy and consequently popular and public acceptance because, quite literally, the proposition was put to the people and the people decided, not unelected judges arriving at a very strained and artificial interpretation of a constitution written in 1937. Contrast that with the position in the United States, where, as David mentioned, the Constitution is almost impossible to amend. As a consequence, US Supreme Court justices are called upon to decide all of these important moral issues, whether it be same-sex marriage or abortion or many other things, and they become almost more important than any legislator in America. They have Secret Service protection following them around, and at the end of Trump's first term, if you asked him what his key achievements were over 4 years, he would have said, one of my key achievements is that I nominated 3 conservative US justices. As it happens, 3 vacancies arose in that 4-year period, and Neil Gorsuch, Kavanaugh and Amy Coney Barrett were all nominated in that 4-year period. And in the first 3 or 4 bullet points of what his achievements were, he would have said nominating conservative US Supreme Court justices to ensure, a row back on abortion and a row back on Roe and Wade, which ultimately happened. Now, is that a better system than ours? I really don't think so. Our judges, as a consequence of the safety valve of the Constitution amendment process, don't have to arrive at strained and artificial interpretations of the Constitution. They can call it as they see it, like Miss Justice Dunn 20 years ago did. And if people don't like the interpretation of the Constitution, there is a sovereign democratic entitlement to amend the instrument. So to answer Ruadhan's question, it does come down to interpretation. There are, of course, rights that inhere in the Constitution, and historically many constitutional rights have been identified by the courts. But that doesn't mean that the courts have licence to interpret the Constitution in a way that it can't reasonably bear that meaning.
You say it's subjective, but we've been talking about the text of the Constitution, and that tells us a certain amount about what's in there. But over the last almost 90 years, the judges at regular intervals have said, I'm going to discover a right, let's say, that isn't in the text of the Constitution. This is the doctrine of unenumerated rights. It has its heyday in the 60s and 70s under Brian Walsh and Carol O'Dolig and all these judges who are much more outward-looking, expansionist by inclination. So they find these rights to bodily integrity, to marital privacy and so on, arguably subjective. You have sort of natural laws and influence where people are looking at the Christian character of the Constitution and coming to judgments like in the Norris case. So there is a certain amount of subjectivity. You might argue that that era has passed, which does give a lot of power to these individuals, Ivana, right?
Yeah, I think it does. And, your book, Ruadhan, of course, highlights the nature of judicial decision-making and the different influences brought to bear. And clearly there's subjectivity there. And I would take issue with, I'm taking issue now with everyone on the panel, but with the Attorney General's depiction of the legal argument in the Zappone case. And very briefly, the Zappone case was a case in which I was the junior counsel. Jared Hogan, who's now in the Supreme Court, was the senior counsel, and we had argued that it should be possible for Catherine and Anne-Louise, the late Anne-Louise Gilligan, they got married in Canada and they looked for their marriage to be legally recognised here in Ireland. And we argued it should be, because it should be capable of being recognised in Ireland, and they should have a right to marry here, because there was no exclusion in the text of the Constitution. There was no exclusion of same-sex couples. Unlike other constitutions, our Article 41 did not define marriage explicitly as just between a man and a woman. So I still believe it would not have been a bizarre reading of the text to say that it was a more inclusive reading. We argued that the Constitution is a living document and should be capable of being interpreted in a more inclusive way. We lost in the High Court, as the Attorney General has said, and of course the case did pave the way then for the referendum. And I do agree with you. Of course, that does give that referendum, that the law on marriage equality is, as a result, has a much stronger basis, is much more embedded in our system. I absolutely agree with you. And indeed, in the US, you can see the difference. Roe v. Wade, the case in the US where the US Supreme Court declared abortion could be legal. And of course, that, because it was a Supreme Court decision, was then capable of being rolled back and indeed reversed by subsequent US Supreme Court decisions, showing the shaky foundational basis. So it would have been a much more solid basis had it been achieved through referendum. However, what I would say, just to finish that point, is that the better approach is not to have lawmaking through either judicial lawmaking, through the Roe v. Wade route, the Supreme Court route, or the route we tried in the Zappone case, nor is it appropriate to have it through referendums entirely. And here's a real flaw in our system. For far too long, legislators had simply shirked the responsibility of making law on issues like abortion, like marriage equality. They were unwilling to touch it, and they left it in the Irish system to judges and then to the people through referendum. So over the course of a number of years, some of you will recall, there were a number of referendums on abortion. Why? Because legislators didn't want to touch the issue. And that was, in my view, not healthy in a democracy. I think the best way of making laws is, indeed, as the Constitution envisages, through the power of the Oireachtas to legislate, as directly elected representatives of the people. And that's the essence of a democracy. So in a functioning, proper, healthy democracy, a republic, we should have most laws generally made for the people, by the people's representatives in Parliament. And that's the better way of approaching it. I think we're much better than the US, by the way, in terms of being able to amend the Constitution. Of course, it does make it a more living and a more dynamic document. But it's still really important that legislators do not shirk responsibility to legislate on matters of fundamental importance to citizens.
David, Rossa has pointed out how hyper-politicised the US Supreme Court in particular is. He's talked about the security detail that Supreme Court judges have and so on, the hearings that they must go through before being appointed, all that. It's such a contrast with the Irish system, where a Supreme Court judge can walk up and down Grafton Street all day long and never get recognised. Nobody knows who they are. They're not subject to parliamentary hearings of any kind. And most lawyers tend to think that that's a good thing. I can hear in my voice a lot of people saying, actually, I'd like to know much more about these people who are making really significant decisions about our lives.
Yeah, I think it's a fair point. I think the fact that we don't know our Supreme Court judges as individual personalities, that I'd say almost no one in the room could identify one Supreme Court judge as being on the left or on the right, as opposed to in the US when you can almost predict decision by decision how judges will come down. I think that's a sign of a healthy legal system, because it seems to be resolving legal rather than political questions much of the time, that there is a legal question presented that is capable of an answer that within the community of the law is accepted as a legal, not a purely political resolution of an issue. And that's what courts do. They give us a forum to try and resolve certain disputes without recourse to political argument by using a set of rules that we've agreed in advance. I think that's a sign that our Supreme Court functions very well. You mentioned, Ruadhan, the very activist period in the 1960s and 70s, and if that had continued, and if political change in Ireland was driven primarily through the courts, that's precisely what might have happened, is we might have paid attention to each and every Supreme Court appointment to find out what was going to happen next on the question of abortion or whatever else. And I think that's not terribly healthy for your legal system, because it means that actual legal questions are then being decided by essentially politicians in robes that have been picked, as Rossa said, because of their political inclinations and views, rather than because they will be impartial arbiters of a legal dispute. So I think that's overall very healthy. At the same time, I think that it's perfectly fair for people to be interested in who judges are and what sort of personalities we are putting on the bench. I don't think being a judge is a purely legal and technocratic set of skills. I think it matters what kind of person you are. I think it matters that you're empathetic. I think it matters that you have a set of values that are broadly compatible with the values that we have in Ireland at this point. And so I think it is perfectly valid to look not just at someone's glittering legal career to decide that they're a judge, but to consider a broader conception of what is meritorious in a judge, what makes a good judge. And I think it's about finding a means to do that without having purely political appointments where it's political party favourites or ideological picks that are getting the nod.
That sort of selection doesn't really happen, right? Where you look at the individual, you look at their characteristics and so on.
No, it doesn't. It's probably a good point to remind the audience that, in fact, our method of judicial appointment has changed very recently. So the Judicial Appointments Commission Act was signed by the President into law at the end of 2023, after it was referred to the Supreme Court on what's called an Article 26 reference, where the Supreme Court rule on its constitutionality on request from the President before he signs the bill into law. And the Judicial Appointments Commission Act, in short, provides that a commission composed of 9 people, 4 judges, 4 lay members and me, will review applicants, will advertise for all vacancies, including a vacancy for Chief Justice or a position of an ordinary judge of the Supreme Court, will review the applications, shortlist for interview the best candidates, and will ultimately recommend, not in any ranking order, no more than 3 names for an individual vacancy, and it is then a government decision. But government has limited room for manoeuvre because government can only choose from within the 3 names that are presented. Now, that's what the Act says. It was introduced to ensure that no future government could appoint unsuitable people. So everybody now being nominated by the government for appointment by the President to judicial office has come through an interview process, an objective assessment process, and theirs was one of 3 names that was recommended by the Commission to the government for appointment.
I remember when I started work on that book, I had assumed that politics would play a big role in political relationships, shared political views would play a very big role in the selection of judges. And what I picked up, the sense I got, I didn't look at every single case, of course, but the sense I got, generally backed up by research that Jennifer Carroll McNeil did more rigorously than I did, is that it's not your politics that determines whether you're going to get onto the bench, it's relationships, or at least relationships are much more important in a small country like this. And so I had politicians tell me the reason I selected, or that person was on my radar, is he did a bit of work for my father 20 years ago, or that sort of thing. And that was quite common. Rossa, you've talked about how the power of the US Supreme Court judges is connected to the fact that the US Constitution is virtually unamendable. I want to ask you about your role. Isn't it a fact also that your advice is unamendable in that, so not you, but the Attorney General as a function, right? The politics of it are such that if you give advice to the government on issue A or B, it's virtually impossible for the government to say, we will ignore that advice. And you have great power as a result.
Well, I think under the Constitution, the Attorney General, by virtue of the wording of Article 30, is the advisor to the government in matters of law and legal opinion. It is always the case that when, for instance, considering new legislation, the government would take legal advice on that legislation before it decides to publish a bill and introduce it into the Oireachtas. And I wouldn't make an apology if I was in the government for saying the government seeks to be rule of law compliant. There are examples of other jurisdictions elsewhere that we can easily think of where government may be, how would I put it, testing the boundaries of legality under other constitutional orders in Ireland, I don't think it's a criticism of the government that they would strive to ensure that legislation they propose is constitutional before they introduce it. So in that sense, it is prudent, appropriate and responsible of any government to take legal advice on whether what they can do is lawful. And that's a sort of a multi-tiered analysis, because the question is it lawful as a matter of Irish law, Irish constitutional law, or are you introducing something that conflicts with other statutory provisions? That's something that has to be carefully considered. But as a matter of practicality now, in the case of many legal measures any Irish government would propose, a really important analysis is whether that is compliant with European Union law. There's a huge amount of European Union law that regulates and governs an awful lot of areas in which a government may wish to legislate. So it is absolutely appropriate that the government would take legal advice on any proposed policy initiative before legislating for it to soundly sort of road test it. And going to the overall question on this panel, has the Constitution atrophied? I mean, the fact that there aren't weekly occurrences of High Court judges striking down statutes as unconstitutional is capable of being seen as a positive thing, because that's indicative of a government that's rule of law compliant, that is endeavouring to stay within the Constitution and is seeking to abide by it. It's not necessarily a negative that there isn't that level of interaction between the courts and the Oireachtas.
Nicely skirted. One of the things about the word atrophied, right, is that it implies that there's all this, that it's not as effective as it could be or might have been because it's neglected or underused or underexploited. I wonder, we've talked about how that era of discovering new rights is pretty much over. Tell me if you disagree. But are there areas of the Constitution that we haven't yet found, is my question. Are there provisions within it that haven't been fully exploited or explored?
Yeah, I think that, as you said, the great era of judicial activism ended quite a long time ago, and we came into a period probably starting in the mid-1990s where the judiciary were unadventurous, is probably the way to put it. They didn't want to make any radical new findings, develop radical new constitutional doctrines. I think what's interesting at the moment is that there are maybe different forces on our Supreme Court. I think that there are some judges that would take the Constitution in a somewhat more expansionist direction. Ivana mentioned earlier on the Supreme Court invoking the idea of constitutional identity, which is common in German constitutional law in particular. The idea that there is an essence to the Constitution that might make certain cedings of power or certain actions deeply problematic, even though the Constitution doesn't expressly set that out. Similarly, some judges on the Supreme Court have invoked the constitutional commitment to democracy to be kind of a thick commitment rather than just a thin commitment. It's not just about democratic institutions where we all vote. Living in a democracy entails certain rights and entitlements that again might go beyond that which is strictly in the text. And the Supreme Court has developed a new doctrine that they call derived rights, which is slightly different from unenumerated rights, which is the old doctrine, saying that if the text and structure of the Constitution suggests strongly that there is a protection that is not listed out, then it's okay for the Supreme Court to recognise that and to enforce that right or entitlement. So that is all happening now, and that seems much more expansionist than anything we saw in the 90s, 2000s, the 2010s. But you also get the sense that there's a large chunk of the Supreme Court, possibly a majority of the Supreme Court, that's not hugely comfortable with those expansions or wants those expansions to remain a limited field and don't want the idea of constitutional identity or constitutional democracy to become a new unenumerated rights. So I think we could see on the judicial side some significant developments of the Constitution that we haven't seen before, but I think if I were betting on it, I would bet against it. I think if we're going to see really new constitutional innovation, it will be in the context of rewriting the Constitution substantially or writing a new constitution in the context of Irish unity or something else, that would, I think, require really radical new thought in a way that we're probably unlikely to see in what is, as Rossa said, a well-developed constitution that works pretty well. That's not a constitution where you're likely to see substantial innovation without some textual change or some new document.
If you're wrong and they do pursue that, it might be your route to socio-economic rights, presumably to right to housing, to environmental protection, whatever it might be. Would that be a good thing?
I think it would be a good thing to have that radical rewrite, but I think, David, I would absolutely agree with David. I don't think that's going to come through judicial lawmaking, and nor really should it. I mean, it is very interesting, and David talks about the different dynamics on the Supreme Court, and certainly in the 60s, in the early 70s, we saw that very expansive approach to judicial lawmaking, and Brian Walsh, and you've documented that. Then that completely slowed down, and really there was a rowing back, as David has said, and judges being much more deferential to the executive and the Oireachtas. And 8 years ago, at the Constitution's 80th birthday, a lot of us were writing at the time and looking at it, and we said, "Oh, the era of judicial lawmaking is over." But interestingly, just reviewing the case law since 2017, I think David's absolutely right. You're now seeing some judges on the Supreme Court who are clearly looking to be more expansive again, to look at not to look at religious ideology or the Christian nature of the state anymore. Rather, you see judges who are drawing from, for example, the European Convention on Human Rights, or drawing from that European idea of constitutional identity. And that was in the Costello case, where the Supreme Court made a very, very significant ruling about the investor courts in CETA, in the Canadian Free Trade Agreement, and really put it up to the executive to have to change the law if they want the state to be able to ratify CETA. So it's a very interesting judgment. But in the course of it, you see judges referring to this constitutional identity. But you also see a wide divergence of views. I mean, the Costello case, and it's not light reading, I think, for anyone. It's 400 or 500 pages of judgments. You see a range of different judgments, and that's no longer unusual, that you would see quite a number of different judgments. A number of other recent cases, big Supreme Court decision that you mentioned, Hinehan again, where judges are giving different decisions, and some are clearly pushing the boundaries a little on these derived rights or on derived principles, shall we say, that aren't in the text, and some are much more conservative with a small c on how they interpret the text. So it's really interesting. It's no longer true, I think, to say, as you were rightly saying in your book in 2016, or I was saying on the 80th anniversary of the Constitution, that judicial lawmaking is finished and judges are no longer referring to anything other than the text. Now I think we're seeing a bit beyond that. Where do we go, though, and how do we develop the text? I think Article 45, for those who don't know, Article 45 is the directive principles of social policy. It's the more communitarian provisions referring to the common good, to the need to protect those who are most disadvantaged in society. So it's the article in the Constitution that those of us on the left really value, because it gives a much more communitarian view. I mean, the fundamental rights article is very individualist in tone, very civil, libertarian, as I've said. You have Article 43, very strong rights of protection for private property. Article 45, I think, gives hope that there's a way beyond that. How do we ensure that becomes more influential or in the text? I think we need a constitutional committee. I think we need to see the Oireachtas setting up again what we had before, a committee to review the language and the text of the Constitution in advance of the 90th birthday, in advance of any unity referendum that is on the horizon, and to look at that rewrite. And Article 45, I think, will be crucial to that. It's been very much underused. And could I just say finally, Ruadhan, Rossa talks about the new judicial appointments procedure. In the company of lawyers, if any of you hear people referring to JAC, JAC is not a person. JAC is the Judicial Appointments Commission. It's the acronym. And many lawyers, particularly those aspiring to judicial office, refer quite frequently to JAC.
Just on enumerated rights, there's a great line from Jack Lynch, who, so the government of the day tended not to like, in the 60s and 70s, what the Supreme Court was doing, and very quickly started to regret some of the appointments that they'd made in that period. There's a line from Jack Lynch where he says it would be a brave man who would predict nowadays what is or is not contrary to the Constitution. It'd be interesting if we're getting back to that more unpredictable era. Rossa, do you want to come in on that?
Yeah, just a few points. I mean, the commentary which is typified by the title to this panel, Has the Constitution Atrophied, I think overlooks a few important points. Firstly, it is a mature instrument. It's 88 years old. That in itself is important. And it means that there's less what I might describe as low-hanging fruit. So a really important decision 50 years ago was the decision in State Healy and Donegal. And that's the decision that established the basic principle that somebody charged with a criminal offence must have the right to legal representation, and that was an inherent right in the concept of a trial in due course of law under Article 38 of the Constitution. That kind of seminal decision is unlikely to be happening as frequently now under a mature instrument. But again, that's not necessarily a bad thing. Second point is this: the perception that constitutional litigation has sort of dried up and that there are no new rights is not statistically borne out. In fact, there are as many declarations of unconstitutionality now in the last sort of decade and a half as there ever were in the 60s and 70s. There might be a lower success rate because there's more of that litigation brought, but if you just analyse it statistically, it is not the case that there were a whole load of declarations of unconstitutionality 50 years ago and now there are none. That's not actually a fair representation. But the other really important thing that I think is overlooked in the debate about the Constitution is that constitutional litigation is a subset of what might be described as rights-based litigation. And many rights-based cases are now based on, firstly, other instruments, including the Charter of the European Union, secondly, the European Convention on Human Rights, but also domestic statute. A really under-examined point is that the amount of litigation that is now rights-based that takes place against the backdrop of claims that statutory entitlements have been breached is very high. So the Oireachtas has legislated in quite a significant and far-reaching way in areas like disability, education, equality and the environment. So very often now people bring rights-based cases saying my right has been breached, but what they're asserting is it's a statutory right that has been breached. And there is a principle of constitutional litigation that the courts will only consider a constitutional question if it's absolutely necessary for the determination of the dispute. So if the dispute can be determined by reference to the question of a statutory right, the courts will determine the case on that basis. And I do think that's an overlooked issue. If you compare now the amount of statutory rights that have been introduced compared to those that existed 50 years ago, there is, in practical terms, less requirement for litigants to actually resort to the Constitution because their starting point is, my statutory rights have not been complied with.
I have to ask about unification because I don't think the word constitution was mentioned last night, but it kept coming back to me because all of these, it was a really interesting discussion between Sarah Carey and Sam McBride. They were talking about symbols, but they were talking about institutions and the structure of a new state. And it occurred to me that really you're talking about tearing the thing up and starting again. It's very difficult to see how you would do all of these things while retaining Bunreacht na Hair.
Yeah, I think that's right. Leo Varadkar suggested previously that unification would require the writing of an entirely new constitution. And I really can't see a way around that. I wrote a paper kind of hypothesising that you could radically change the constitution in so many ways. You would keep some structure of the current one, but swap out so many planks that, like the ship of Theseus, it could be a new constitution at the same time. But I think even that would have so much baggage around it being the constitution of this state that would be continuing, and the continuity there, I think, itself would present symbolic issues, because I think the idea of a new start and a new state in the event of unification would be crucial. But also, just from a practical point of view, as we heard last night, there are so many unanswered questions about what the structure of that state might be, about what sort of political system it would have. Is it federal, confederal, unitary? What level of delegation down to provincial level would you see in various powers? There is very little in the Constitution of 1937 that provides for that. The idea of unification that is in that document, the preamble, aspires to the unity of the country. I think was quite naive. It was the idea that at some point Northern Ireland would just join in this state and things would continue, the German model as it was referred to last night. And really the Constitution doesn't provide for a great deal beyond the fact that the territory of the state could encompass the whole island at some stage, and maybe you could have a local legislature or something. It doesn't really think about what unification would look like, certainly not in any serious way like we were discussing last night. So I think, yes, it would require a new constitution. I think the challenge of that, because I do some kind of work in constitutional design, is if you have a blank page, if you have nothing agreed, then every single issue in the Constitution becomes a possible point of disagreement.
Look at that.
Yeah, and that's the benefit of trying to retain some document as a baseline, so you don't have to put every single point of the structure of the state up for discussion in what would already be a very difficult process. But I think the scale of the changes are so significant that if you tried to do it as an amendment job on Bunnock na hÉireann, you would be left with almost nothing left of that original document, and you'd wonder, would there be a great advantage to doing it that way?
Before we open up to questions, does anyone else want to come in on that?
Well, just briefly, I do think, last night's discussion was fascinating with Sam McBride and Sarah Carey, and certainly it does throw up that need to do a radical rewrite. But, what also emerged from that discussion was the need for groundwork. And that's why I say, a joint Oireachtas committee on the Constitution established now, a key part of its function would be to prepare the ground for what rewriting precisely would be necessary. And I think you'd have to approach it on the basis of, let's keep the framework, but see where we need to change things to ensure that unification could proceed as smoothly as possible. And, there's an interesting thing about the 1937 Constitution, is that it's still a transitional constitution. There's reference in it to Seirstead Éireann and the laws of Seirstead Éireann, the Irish Free State. So it acknowledges that need for transitional and incremental change that I think you could build into a rewrite. But a joint Oireachtas committee, careful groundwork, green paper and white paper in advance of the holding of any referendum. I think that's all essential if we are to avoid the mistakes of Brexit, to ensure that people go into it, both north and south, fully informed, fully engaged in the process.
Of course, it doesn't mention Republic, as you said earlier. I get that into. Does anybody want to come in? Anybody in the audience? The first hand went up is here on the right, on my right. Do we need to get a microphone to people? Give it a go, yeah. I can hear you anyway.
I know you said, Attorney General, that you did look at a controversy-free diet. I know you said, Attorney General, you're living on a controversy-free diet, but so hopefully this isn't too controversial. Article 29 of the Constitution confirms that we are going to follow international law, which supersedes European law, and humanitarian law also. And that means we follow the ICJ ruling, especially the one from July last year, which concerns Israel's genocide of Palestinians. We heard, that the government has a sort of an overseas territories bill, Mark II, which is going through. And we heard yesterday from Danny McCoy that, it's as a bill. It is. I'm trying to remember what the word is. Anyway, it's not doing a lot in terms of it only affects 250 grand's worth of imports. And we heard also from Bridget Laffin that if we're going to use up political capital, we should do it wisely. But we've used up the political capital. We put it into the programme for government that we were going to do this. So if we're going to use it wisely and not be, as Danny said yesterday, doing so little and being hypocritical, then maybe we should look at doing much more and following international law and putting much more into this. Because we could actually have a situation where, rather than just sanctioning the products that are coming in from the occupied territories, which is just East Jerusalem, Gaza Strip and the West Bank, we could do goods and services and do it for the whole of Israel. And that would achieve what we are really looking forward to doing, which is to actually getting the Palestinian, the horror that they're facing at the moment, stopped. To get European nations to come along with us and other states. But there's a huge benefit for Ireland also, and that is in terms of our peacekeeping duties, because it would show the rest of the world what a strong moral compass that we do have, and a trustworthy international partner. And just to last a further point, the government sort of put little handcuffs on itself earlier on in the year by adopting the anti-Semitism definition, the IRHA definition, rather than something like the Jerusalem Declaration. The Jerusalem Declaration doesn't include, criticism of the State of Israel, whereas the IRHA definition does. So maybe that government decision should be changed. And I know you probably can't answer any of what I've just said, but I'm actually going to leave it up to the leader of the Labour Party and the law professor from UCD to tell us what you maybe should do. Thank you.
We'll just take one other question before we come to that. We'll come back to it. Just the third row here on our left, purple shirt. Yeah.
Thanks, Dermot Lacey. First of all, thanks to the three speakers. You actually made a rather dry subject quite interesting, so I really appreciate that.
Thanks, I think.
The question I want to ask is about the duty of the Oireachtas to respect the outcome of referendum. My first vote as a citizen was in 1979 when I voted on the Shannon changes. It took the Oireachtas 45 years to move. I was actually on the losing side on that occasion. I nearly always have been on the losing side. But the second and one that really matters to me is the 20th Amendment to the Constitution, which recognised the role of local government. Every single government since that referendum was passed has reduced the powers of local government, has reduced the financing of local government, and has reduced the number of councillors we have in this country. Now, implicit in adopting that referendum was that local government was going to be strengthened and enhanced. I mean, that was the very point of it. Well, in theory, that was the point. The governments, all governments, have clearly broken that commitment since that referendum was passed in, I think, 1999. What on earth is the duty of the Oireachtas to respect the people's decisions on referendums to amend the Constitution? Because I don't think any government since 1999 has honoured the outcome of that particular referendum.
Thank you. Rossa, we'll come back to the first question first.
Yeah, I'll just be polite and say I can't respond to Alex's question because that's an issue upon which I legally advise government. Ivana will have no equivalent constraint. In relation to Dermot's question, he modestly omitted to say that he is in fact a long-serving councillor himself. For those of you who don't know him, and is a former Lord Mayor of Dublin, I think, and is a councillor, in fact, in my own constituency. The 20th Amendment inserted Article 28A into the Constitution. It's a matter for the Oireachtas, as a matter of first principles, when any constitutional amendment has been drafted, to decide whether or not it is necessary to legislate to give further texture to what has been provided for at a constitutional level. But that's a matter for the will of the Oireachtas, and I can't put it further than that.
Well, Dermot, thank you for the question. And of course, Dermot is not only a councillor in Dublin Bay South, but a Labour councillor who was also my director of elections in the last election. So I'm very glad to say Dermot is not always on the losing side. And indeed, we've had a number of good wins, Dermot. And thank you for the point. I think you're absolutely right. And it's something that we and the Oireachtas need to do more on strengthening local government. I couldn't agree with you more. Alex, thank you for the really passionate intervention on the Occupied Territories Bill. And again, just to agree with you, absolutely we should be legislating to prohibit trade in both goods and services with the occupied territories. And, we have on the opposition benches very strong legal advice that suggests not only that we can do this, but also that it is an international legal imperative that we do this, given the ICJ advisory opinion, given our obligations under international law. In my own role as leader of a party that's in the Party of European Socialists, I've been engaging with other socialist leaders from across the EU, just as the Taoiseach has been engaging and the Taoiseach have been engaging with other heads of government from across the EU, seeking support across the EU for similar legislation in different states. We know that Spain, for example, is looking very closely at bringing forward forward domestic legislation in a similar vein. So we want to do this. But the key point here is, in the Irish context, is that the government are currently, and I will say this, hiding behind the Attorney General advice, and again with respect to Rossa sitting beside me, and that, I recently brought forward a bill that would enable the government to publish Attorney General advice, where it's not about a specific piece of litigation, where there's no privacy issues for an individual, but where it's about something as fundamental as, can the state legislate to prohibit trade in goods and services from occupied territories? Something, a policy issue on which we as Oireachtas members have to debate and discuss and determine. That we should be able to see the Attorney General's advice. It's advice to government, it's legal advice. The government ministers are standing up telling us we can't do this because the Attorney General advises we can't. We are debating with our hands tied behind our back, but we haven't seen the Attorney General's advice. We've published our advice. It's out there in the public domain. The Foreign Affairs Committee have been debating it all week. We need to see that advice because we believe we can do this, and we should do this, when we see 58,000 civilians murdered in Gaza under an Israeli genocide. We have a moral and legal imperative to do this. So I couldn't agree with you more. Thank you.
Thanks to Dermot for the question. I'm glad that we could make a dry subject interesting, and all I can say is, if you think this was dry, have sympathy for my students who have to deal with several months of this. And just very briefly, I think, speaking a little bit to both points, I think the fact that we have a robust judiciary in this country and that judges can step in and sometimes correct a constitutional wrong, such as an amendment that hasn't been implemented by the Oireachtas, while that can happen, and that's important, I think what we really need to remember and what we really need to encourage is what we sometimes call a culture of political constitutionalism, that the Constitution is not just for the courts, it's for the Oireachtas, and in fact the courts will say this over and over. The Oireachtas has special competence in balancing different social issues, in balancing constitutional rights, and one thing that our political system hasn't always robustly developed is a strong sense of what the Constitution means in politics and how it should be regarded in the houses of the Oireachtas. Ivana mentioned the directive principles of social policy in Article 45, principles that are supposed to be directing how we legislate. They are never mentioned. They never come up. No one talks about them. No one relies on them. Ivana, of course, does. But I think it would be worth remembering that we need our politicians to be active, to take their constitutional responsibilities seriously, because we can't always rely on the courts to fix problems like unimplemented referendums.
We're running up against the clock, so we just have time for a couple more questions. Are there any women's hands? I have a lot of men's. Just here, yeah.
Hi, Anya Monaghan. Just wondering, the 3 lay people on the interview panel for judges, where do they come from? Who decides who they are?
We'll just take 3 quick questions together, just beside yourself, yeah.
And bearing in mind how we select our Supreme Court judges, I'm wondering how we appoint our Attorney General.
You can take 10 seconds to think of that. And just in the middle here, if you stand up, yeah.
I found the story about the same-sex kind of court case really interesting, to kind of take a blow to get the referendum through. I was actually having a question for you, Ivana. With being so passionate about having he or she as president, would you be willing for the presidency to only be excluded to men, to be able to push for a referendum for women and men to be included in that language?
Thank you for 3 very succinct questions. Can you answer them as quickly as they were asked?
Well, the first 2 are for me. I think on the question of who chooses the lay people on the Judicial Appointments Commission, they were the subject of a nomination by the Minister for Justice. There was what we call a PASS process, the Public Appointment Service. So there was an there was a transparent application process. The legislation itself gives guidance as to the different types of sectoral expertise that should be represented by the lay people. So there are 9 people on the Commission. Typically the interview panels will be a subset of the Commission and will be 3 people, including at least 1 lay person and at least 1 judge. The names of the 4 lay members are publicly available on the Judicial Appointments Commission website. On the second question, how do you get the job of Attorney General, the Constitution answers that. You are nominated by the Taoiseach and appointed by the President. I've had the good fortune to be nominated now by 3 Taoiseach in a relatively short period of time, Leo Varadkar, Simon Harris and Micheál Martin, and on each occasion there is a formal appointment by the President. So ultimately that's a discretionary matter. Historically, the Attorney-General has always been a senior counsel. In a couple of cases they had to become a senior counsel in a hurry just to become Attorney-General, but in fact the Constitution doesn't impose that limitation. As a matter of theory, somebody without legal training or a solicitor could be Attorney-General, though it hasn't happened to date. Historically, the view is an experienced senior counsel is the appropriate type of qualification to hold the office.
Anyone else want to come in on either of those, or the 3 questions?
Well, just briefly, Rossa has described his appointment process and history, and it's notable. I know you'll be discussing the presidency here tomorrow, and it's notable that, of course, Rossa, none of us here have ruled ourselves out on this panel. And
I was going to get to that,
and
Ivana.
more seriously, Rossa's the only, I think I'm right, the only state officer ever to have been nominated for position by both Fianna Fáil and Fine Gael. So just take of that what you will. On the third point, and thank you for the question, yes, we will be pushing for a referendum to well, what we want to see first is a constitutional committee that would recommend that radical rewrite and how that would work, and as part of that process to degender the articles, not just Article 12, but throughout the text where he is used rather than he or she, and indeed, as I said, to ensure that references to God are removed. Not just a Labour Party initiative, others are pushing too for this. It's a part, I think, of an essential process of modernising the Constitution. And just in terms of modernising laws, I just want to hand the Attorney-General a copy of a bill that I recently introduced to... no, not that one, different bill. You struck down, the government struck down the last one. This one is to enable the state to take action against unincorporated associations. In other words, so that religious orders would be we could compel religious orders to pay their fair share of redress to victims and survivors of abuse.
Since you've raised it, are you thinking about a run for the presidency?
I think I can rule myself out here, Ruadhan. There's your scoop.
Well, we had reporters ringing you last week, and you didn't. You chose not to rule yourself out. So I'm glad that we've got it on the record. David, do you have anything you want to add very briefly on any of those questions?
Just very briefly on the appointing the Attorney General point. Just interesting to note that if you look at other common law jurisdictions, look at England, look at Canada, the Attorney General's office is actually a more political office. It's usually a serving member of the lower house, often with legal training as well. But Ireland takes a kind of uniquely legalistic view of the role of the Attorney General around the common law world. It's a mixed legal and political role. So we're kind of distinctive in the fact that it's always a senior counsel of long standing. Has on a couple of occasions also been a member of the lower house, but it's much more common for it to be just a lawyer of long standing and great experience.
I'm sorry we can't get to more questions. Can you please put your hands together? Oh, is there one more? Sorry. I'm being told I have one more that I have to take down here.
Yeah, sorry, Ruadhan. Sarah Carey, I'm abusing my position here with the lads. Excuse me. 2 quick things on Attorney General's advice. As far as I'm concerned, Roger O'Gorman willfully misrepresented the Attorney General's advice in those referendums, and there has been no accountability for it. To Ivana, 58,000 people have died in Gaza. 250,000 have died in Yemen and millions in Congo. And there's hardly a word about them. Why do some deaths matter more than others?
Well, very briefly, Sarah, on the second point, we have certainly, and I was our foreign affairs spokesperson for Labour for some years, we certainly highlighted hideous deaths, hideous war and conflict, not just in Yemen, which I agree with you is the forgotten war, but in Sudan and other places. We've been to the fore in condemning Russia's brutal invasion of Ukraine and the slaughter of civilians there as well. So it's not that some deaths matter more than others, far from it. But uniquely, Israel has a very particular position as a trading partner with the EU. We have an EU, as you know, a trade agreement. There is a far greater level of subvention of the Israel Defence Forces from European states than there is directly into Yemen and other countries. So I could go on, but I think there's a very clear reason why here there is such desperate distress and horror at what's going on in Gaza. I think the scale of that and the scale of the slaughter of civilians there, the scale of the devastation and destruction means that's the case. I've absolutely condemned Hamas and their barbaric attack in October 23, as I think all of us should. But Israel's response has been so grossly disproportionate and so genocidal in effect that I think, it's something I have to say. Anyone who stood for election last year, on any party, was struck by how distressed people were, voters on doorsteps raising it with us every single day. Why aren't we doing more to stop the slaughter in Gaza? So that's why we are focusing on this. That's why the Occupied Territories Bill has become so important, because at EU level it's also hugely important. And finally, just on your point about the AG's advice at Roger O'Gorman, I couldn't comment because I haven't seen the AG's advice, and that's precisely the point. The AG selectively leaked, and we never saw the full thing. So I think that's the problem, and that's why we do need to see Attorney General's advice published, and we need to see a government that is more transparent about the legal advice, not hiding behind it without revealing it to opposition.
Folks, I'm going to have to wrap this up. Thank you for coming, and thank you to the panel for